Good morning to all the distinguished participants. My presentation is based on the information contained in the Cauvery Water Disputes Tribunal report, Supreme Court judgment dated 16 February 2018, and the Government of India notification dated 1st June 2018. These documents are available in the on the websites of Central Water Commission and Ministry of Jal Shakti. Now, without further loss of time, I shall start my presentation. The conflict on Cauvery dates back to the middle of the 19th century when the Mysore government, while restoring their old irrigation works, also wanted to build a number of new irrigation projects. This caused anxiety to the then state of Madras. Government of Madras took up the case with Mysore government and Government of India. Besides Cauvery, the dispute also involved other rivers flowing through through Mysore into Madras Presidency. After a lot of discussions and correspondence, an agreement was reached on 18 February 1892, covering the interstate rivers, and was framed in the form of rules. The 1892 agreement, as I have said, was entered into between then princely state of Mysore and the British Presidency of Madras on 18 February 1892, and termed as the rules defining the limits within which no new irrigation works are to be constructed by the Mysore state without previous reference to the Madras government. There are many clauses in the agreement. Clause 2 of the agreement provided for that Mysore government, without previous consent of Madras government, will not build any new irrigation reservoir across any part of 15 main rivers in Schedule A. What is new irrigation project? That is also defined in the agreement. Any part of 15 main rivers in Schedule A or across any stream named in Schedule B below the points specified in column 5 of the said Schedule B, or in any drainage areas specified in the said Schedule B, or any cut across the stream of the Schedule A numbers 4 to 9 and 14 and 15, or across any of the streams of Schedule B, or across the specified streams of Schedule A lower than the points specified therein. Main Cauvery is mentioned at serial number 10 of the Schedule A. Under Rule 3 of the agreement, it was provided that when the Mysore government desires to construct any new irrigation reservoir on any cut requiring the previous consent shall be forwarded to the Madras government, and the consent of that government shall be obtained previous to the actual commencement of the work. The Madras government was not bound to refuse except for the protection of prescriptive rights already acquired and actually existing. Rule 4 of the agreement provided for the reference of any dispute of opinion under Rule 3 to the final decision either of arbitrators appointed by both the governments or of the Government of India. The Mysore state proposed the Krishna Raj Sagar Dam and sought the consent of Madras government in terms of the aforesaid agreement of the year 1892. Madras Presidency protested against the construction of the dam, and the matters were referred to the arbitration by Sir H.G. Griffin, Honorable Judge, High Court of Allahabad at that time. Sir Griffin gave his award, but Madras government did not agree with the arbitration award and filed objection before the Government of India. The award was ratified by the Government of India. Madras government then appealed to the Secretary of State for India, who reopened the question. The Secretary of State advanced options either for fresh arbitration or negotiation. Mysore state opted for negotiations, and the two governments entered into negotiations. As a result of such negotiations, certain rules of regulations of the proposed Krishna Raj Sagar reservoir were framed, and agreed upon by the chief engineers of both the governments on 26 July 1921. The discussions continued and finally an agreement was entered into on 18 February 1924. 1892 agreement was a general agreement for a number of rivers, but this 1924 agreement is specifically for Cauvery. Under this 1924 agreement, Mysore was permitted the Krishnaraj Sagar Dam and Madras was permitted Meteor Dam. The agreement also permitted both the states the extension of irrigation by bringing in new areas. The regulation system, which was agreed on 26 January 1921, was revised by an agreement entered on 17 February 1929. The agreement also provided, agreement of 1924, also provided that after 50 years, that is after 1974, certain clauses would be open to reconsideration in the light of the experience gained. Mysore government sometimes during 1950s and 60s started work on 4 reservoirs, Kabini, Himawati, Harangi and Suvarnavati. Fresh disputes arose between Tamil Nadu and Karnataka when the work was started by Karnataka on these reservoirs. Tamil Nadu government objected to the above projects and approached the government of India for intervention in the matter. Number of interstate meetings were held to settle the matter. 5 such meetings were held in 1970 alone. In the interstate meeting held on 29 May 1972, it was emphasized that the river programs are best settled by negotiations and the following was resolved. A serious attempt would be made to resolve by negotiations the Cauvery water disputes. The center may appoint a fact-finding committee, which was appointed and was known as Cauvery Fact-Finding Committee. The center may appoint a fact-finding committee consisting of engineers, retired judges, and if necessary, agricultural experts to collect all the connected data pertaining to Cauvery water, its utilization and irrigation practices, as well as the projects both existing, under construction, and proposed in the basin. The committee will be examining adequacy of present supplies or excessive use of water for irrigation purposes. The committee was only to collect the data and not to make any recommendations. Making use of the data, discussions will be held between the chief ministers of the 3 states to arrive at an agreed allocation of water. The third state is Kerala here. Union government will assist in arriving at such a state settlement in 6 months. As per the resolution, fact-finding committee was set up on 29th May 1972. The committee was known as Cauvery Fact-Finding Committee, CFFC. CFFC submitted its report on 15th December 1972. Earlier, actually, they had sought 1 month's extension, but that was not granted and they had to submit the report on 15th December 1972. As per the resolution in the meeting of 1972, the committee refrained from making any recommendations. CFFC assessed the yield at 50%, 75% and 90% dependability at various locations. Krishnaraj Sagar, Meteor Reservoir and Lower Anicut, the dependable yields are given in this table. We can see that at Lower Anicut, the yield at 50% dependability is 740 TMC and at 75% dependability it is 670 and at 90% it is 623 TMC. The report of CFFC 1972 was considered by the Honorable Chief Ministers of the Cauvery Basin States on 29th April 1973. The tenure of the CFFC was extended with the following terms of reference as per the discussions of the held in that meeting. The committee shall review the data supplied to it earlier by the state governments in respect of area cropped, net area irrigated, irrigated cropped area, and other data relevant to water utilization at different points of time, and undertake such verification as is necessary from other data available with the state governments, especially those published. The CFFC accordingly submitted an additional report On 14th August 1973, it furnished in the report on the area and utilization at different points of time. Those figures are given in this table, how the irrigation developed in the various states. Here, Tamil Nadu includes Union Territory of Puducherry also. So we can see that in 1971, the total area as reported in the additional report was 35.566 lakh acres. Committee also in its additional report gave the water utilization figures for the various years 1901, 28, 56 and 71 for the three party states. Here Tamil Nadu again includes Union Territory of Puducherry. We can see that in 1971 the total utilization was about 748.42 TMC. Government of India, in order to settle the differences, continued with holding the interstate meetings. A draft understanding was put up by the Government of India officials in 1974. That draft was not agreed. Again in 75, another draft was put up, that was also not agreed. Based on 1974 draft, a modified draft was presented in 1976, and on 25th August 1976, an understanding was reached to ensure optimum utilization and equitable distribution. In that understanding, it was agreed that existing utilization in the Cauvery basin was agreed as 671 TMC, comprising of 489 TMC by Tamil Nadu, 177 TMC by Karnataka, and 5 TMC by Kerala. In a normal year, the existing area under irrigation shall be fully protected. This was agreed. In the lean years, the manner of sharing the available water shall be worked out by a committee of representatives of the central and state government. The committee shall also work out the quantities of the surplus water presently available over the existing use of 671 TMC, which shall be shared in this ratio of 30, 53 and 17 amongst the states of Tamil Nadu, Karnataka and Kerala respectively. It was also there in the understanding that Tamil Nadu and Pondicherry shall take steps to effect savings of 100 TMC from present use, and Karnataka shall take steps to effect a saving of 25 TMC from its present use by various measures such as modernization of the existing irrigation system, improvement in water management and reducing losses. The same shall be shared in the ratio of 4, 138, 53 amongst the states of Tamil Nadu, Karnataka and Kerala respectively. The share from 125 TMC shall be distributed as 4 TMC for Tamil Nadu, 87 TMC for Karnataka and 34 TMC for Kerala. A Cauvery Valley Authority shall be constituted with the representative from states as members and the chairman nominated by the central government. Then Ministry of Agriculture and Irrigation constituted on 17 September 76 a committee of secretaries of the basin states with the Director Central Water Commission as the secretary to draft the functions and rules of procedure of the Cauvery Valley Authority. However, the consensus could not be arrived at and the committee submitted a draft report with divergent views. Committee of Technical Officers with members, Central Water Commission as Chairman and Chief Engineer, Government of Karnataka, Advisor Irrigation Project, Government of Kerala, Chief Engineer, Government of Tamil Nadu as members, and Director, Central Water Commission as Secretary was constituted on 12th October 76 with the terms of reference as shown here to assess the requirement of water of the existing areas under irrigation as well as new areas which are proposed to be brought under irrigation, taking into consideration the availability of water from the rainfall within the respective command areas. To assess the availability of water for use in a normal year, taking into consideration integrated operation of the reservoirs and the demand pattern of releases. To recommend regulation of supplies in normal or good years for protecting the existing ayacuts as well as for the new areas, taking into consideration the savings to be effected progressively in Tamil Nadu, including Karaikal region of Pondicherry and Karnataka. Recommend a workable and equitable formula of regulation and availability of supplies for irrigation and existing ayacuts and new areas in lean years. To determine quantities of water available as a dependable surplus for further use and to propose sub-basin wise allocations for Kerala. Here again, the committee could not finalize the report because of divergent views of the states. The government of Tamil Nadu forwarded a complaint under Section 3 of the Interstate Water Disputes Act 1956 on 6th July 1986 to the Government of India on demanding for constitution of a tribunal. Similar complaint was earlier filed by the state of Tamil Nadu for the constitution of the tribunal before the Government of India in the year 1970, followed by reminder kind of complaints on several occasions during the years 1970 and 71. The Farmers Association of Tamil Nadu, a society registered under the Tamil Nadu Societies Registration Act, filed an application under Article 32 of the Constitution requesting the Honorable Supreme Court for direction to the Union of India to refer the dispute relating to the water utilization of the Cauvery River and equitable distribution and for amendments to the state of Karnataka not to proceed with the construction of construction of dams, projects and reservoirs across the said river and or any of its tributaries within the state and to restore supply of water to the state of Tamil Nadu as envisaged in the agreement of 1924. The petitioner alleged that the inflow into the Cauvery at Metul Dam as also downstream has considerably diminished due to the construction of new dams, projects and reservoirs across river Cauvery and its tributaries by the state of Karnataka. The state of Karnataka, by filing several affidavits, opposed the maintainability of the petition as also the tenability of the plea for relief. Union of India in the Ministry of Water Resources also opposed the maintainability of this application. The state of Tamil Nadu filed an affidavit in the court wherein it not only supported the contention of the petitioner, but effectively joined the dispute by adopting the stand of the petitioner. The state of Kerala left the matter to the good sense of Union of India to bring about an amicable settlement. The Honorable Supreme Court delivered its judgment on that petition on 4th May 1990, wherein it had directed the central government to fulfill its statutory obligation and notify in the official gazette the constitution of an appropriate tribunal for the adjudication of the water disputes. Accordingly, the government of India constituted the Cauvery Water Disputes Tribunal on 2nd June 1990. This is a map of the basin, map of the Cauvery River Basin. This is one map of Cauvery Basin showing hydrometric networks. This is included in the volume 6 of the Cauvery Water Disputes Tribunal final report. These are drainage area figure in the Cauvery Basin of various party states: Karnataka, Tamil Nadu, Pondicherry, and Kerala. After the constitution of the Cauvery Water Disputes Tribunal, civil miscellaneous petitions were filed on behalf of the state of Tamil Nadu, praying that the state of Karnataka be directed not to impound or utilize water of the Cauvery River beyond the extent impounded by them as on 31st May 1972. A prayer was also made to restrain the state of Karnataka from undertaking any new projects, dams, reservoir, etc. Tribunal dismissed the petitions filed by the state of Tamil Nadu and filed by the Union Territory of Pondicherry for interim relief, inter alia upon the view that the central government had as yet made no reference to the tribunal for adjudication of the interim reliefs prayed in the said civil miscellaneous petitions, and hence the said petitions for interim reliefs were not maintainable. Being aggrieved by the tribunal order, where they said these are not maintainable, the civil miscellaneous petitions, the state of Tamil Nadu and Union Territory of Pondicherry had respectively filed civil appeal numbers 303, 304 of 1991 and civil appeal number 2036 of 1991 before the Supreme Court of India. On 26th April 91, the Supreme Court allowed the said appeals and directed that the said civil miscellaneous appeals be decided on merits by the tribunal. The tribunal passed an interim order on 25th June 91 on the applications of July 1990 filed by the state of Tamil Nadu and Pondicherry. In the interim order, Based on the data of flows to mature for 1980-81 to 1989-90, tribunal directed Karnataka to ensure 205,000 million cubic feet of water in a year at mature reservoir of Tamil Nadu based on a monthly schedule. They have prescribed a monthly schedule there. Tribunal further directed that Karnataka shall not extend its irrigation beyond the existing 11.2 lakh acres using Cauvery water. It said the order will remain operative till the final adjudication of the dispute referred to the tribunal. On 25th July 1991, the governor of Karnataka promulgated an ordinance, namely the Karnataka Cauvery Basin Irrigation Protection Ordinance 1991, to protect the interest of the state of Karnataka and to negate the effect of the interim order dated 25th June 91 passed by the tribunal. On 27 July 1991, a presidential reference was made under Article 143 of the Constitution. 3 questions were referred for the opinion of the Supreme Court. First, whether the ordinance and the provisions thereof are in accordance with the provisions of the Constitution. Second, whether the order of the tribunal, that is interim order, constitutes a report and a decision within the meaning of Section 5(2) of the Interstate Water Disputes Act, and whether the order of the tribunal, interim order, is required to be published by the central government in order to make it effective. Third question, whether a water disputes tribunal constituted under the Act is competent to grant any interim relief to the parties to the dispute. We can see that question number 3 was already answered by the Supreme Court, that after which the tribunal considered interim relief applications. A 5 judges bench of the Supreme Court answered the reference on 22nd November 1991. The ordinance Karnataka, which was issued by the Karnataka, was held to be invalid and unconstitutional and beyond the legislative competence of the state. The order in question, that is the interim order, constitutes a report and a decision within the meaning of Section 5(2) and is required to be published by the central government under Section 6 of the Act in order to be binding on the parties and to make it effective. This is what the opinion was given. The Supreme Court had already expressed its view in its order dated 26th April 91 on the appeal filed on behalf of the state of Tamil Nadu and Union Territory of Pondicherry, saying that the tribunal had jurisdiction to consider the question of grant of interim relief. In 1992, Tamil Nadu filed original suit in Supreme Court OS number 1 of 1992, seeking to direct Karnataka to comply with the interim order and for directions to the Government of India for constitution of an authority to give effect to the interim order. On 21st March 1997, Supreme Court passed an order that the matter is to be decided by the Constitution Bench. During the arguments before the Constitution Bench on 9th April 97, Attorney General of India made a statement that the Government of India was agreeable to frame a scheme under Section 6A of the Act. After further discussions with the states, Government of India notified a scheme on 11th August 1998. The scheme constituted of a Cauvery River Authorities, CRA, headed by the Honorable Prime Minister as chairman and chief ministers of party states as members, along with a Cauvery Monitoring Committee, CMC, with Union Water Resource Secretary as chairman and chief secretaries of party states as members to assist the Cauvery River Authority. The CRA and CMC performed till May 2013, overseeing the implementation of the orders of the tribunal, after which a supervisory committee was constituted. Before the tribunal, these were the claims of the states. Karnataka pleaded for 465 TMC of water, Tamil Nadu 566, Kerala 99.8, Puducherry 9. So we can see that the total was much more than the yield available in the Cauvery Basin at LCA at 50% dependability, which was 740 TMC as per CFFC. Accordingly, tribunal found that some curtailments in the demands of the states have to be made. The tribunal To ensure equitable share to each state, applied the following criteria. Double paddy crop only over areas before the agreement of the year 1924. Double crop only over areas before the agreement of year 1924 and as permitted under the said agreement, that is 1924 agreement, and not beyond. Summer crop restricted in some areas where it was grown prior to 1924 agreement, which ought to be replaced by any light irrigated crop within the irrigation season. That is what tribunal did to ensure equitable share. Sugarcane, tribunal found that requires more water affecting the equitable distribution. Note was taken of area for sugarcane only up to 40,000 acres in Karnataka. The delta of water claimed on behalf of the two states of Karnataka and Tamil Nadu, including paddy, have to be reduced in view of the new variety of paddy developed of late, which required less water. Trans-basin diversion not considered for determining the equitable share of each state. Lift irrigation was also not considered for water allocation. The tribunal estimated the delta for paddy crop in Grand Anicut Canal system. The delta for paddy in the delta system was determined by applying increased efficiency from 60% to 65% of the delta claimed by Tamil Nadu. In case of other projects, the delta was determined by applying the increased efficiency of 65% to the delta pleaded by Tamil Nadu. The delta for paddy for Amravati project was estimated by the tribunal. About Karnataka, the tribunal worked out the delta for Kharif paddy crop for existing projects and ongoing projects falling below Krishnaraj Sagar, including KRS command, by modifying the percolation losses and system efficiencies claimed by Karnataka. The tribunal worked out for Kharif paddy by simple calculation for Harangi project and adopted for areas above Krishnaraj Sagar. They divided the area in two categories, above KRS and below KRS. The second point, above KRS, they worked out for Harangi project and adopted the same for upstream of KRS, and for downstream as given in the under first point. For semi-dry crops in both Kharif and Rabi season, the delta claimed by Karnataka was modified and adopted. About Kerala, Kabini sub-basin was allowed two paddy crops. Actually, tribunal found that in the first crop, the delta required is very less, very little delta is required, because the southwest monsoon in the Kerala portion, they found that it is generally it provides the necessary water. Very small irrigation water is required, and then they allowed the second paddy crop also in Kaveri basin, and one vegetable crop during summer, similar to the Karapuja project approved by the government of India. Karapuja project was earlier approved by the government of India. There also two paddy crops and one vegetable crop were approved. The vegetable crop is considered to be grown during summer with residual moisture in the valleys wherever possible. Bhavani sub-basin was allowed one paddy crop during northeast monsoon and semi-dry crop during southwest monsoon. Pambar, that is Amravati sub-basin, Pambar sub-basin was allowed one paddy crop and one semi-dry crop. Mananthawadi and Kerala Bhavani hydro and diversion for augmentation of Kutiyadi hydroelectric project in Banasur Sagar project were not allowed, since they involved trans-basin diversion. The tribunal had taken that view that no trans-basin diversion will be allowed. Lift irrigation was not allowed. About Puducherry, tribunal noticed that it has its own compulsions in as much as there is no scope for any extension of areas beyond 27,000 acres of first crop and 16,000 acres of second crop. The claim for second crop of paddy was allowed in case of Puducherry. The tribunal also assessed the domestic and industrial water requirements of the party states. They sought the population figures for the year 2001 and 2025 projected figures. Domestic water requirements, however, the tribunal estimated only for population projected for the year 2011. Domestic water requirements were considered to be met 50% by surface water and the remaining 50% by groundwater. Industrial water requirements have been considered for the projected scenario for the year 2011. The tribunal also mentioned about the conjunctive uses for domestic and industrial uses. For domestic uses, they said 20% will be the conjunctive use and 80% will return back to the river. And for industrial, it 2.5% will be the conjunctive use. However, in case of Puducherry, they said that no return flow will be possible and 100% requirements was taken as conjunctive use. After assessing the irrigation and domestic and industrial water requirements, tribunal found that at 50% dependability, actually tribunal has allocated the water at 50% dependability at LCA, that is 740 TMC. There was an issue whether the allocation should be on 50% or 75%. The tribunal decided for in favor of the 50%. And after assessing the irrigation, drinking and domestic water requirements, tribunal found that there is still a balance of about 45 TMC, balance from that 740 TMC. So share in that balance water of 45.08 TMC has been distributed in proportion to 1991 in basin population of the party states. Only in basin population was considered. Environmental protection was allocated 10 TMC for allocation from common pool, 2.5 TMC per month from 1st February to 31st May shall be ensured at Biligundu by Karnataka for environmental protection. Inevitable wastage of 4 TMC was also agreed. These are the final allocations as per the Cauvery Water Disputes Tribunal Award. Here they have given the area in lakh acres, irrigation requirements in 1000 million cubic feet, domestic and industrial water requirements projected for 2011. These are conjunctive uses only. For Puducherry, 100% was taken as conjunctive use. For remaining, it was 20%. For domestic and for industrial, 2.5% for other states and 100% for Puducherry. Water requirement for environmental protection, inevitable escapages into sea, and then share in balance water based on 1991 in basin population, 45.08. So accordingly, these are the figures. We finally rounded off to 30 TMC for Kerala, 270 for Karnataka, 419 for Tamil Nadu, 7 for UT of Puducherry, 10 towards environmental protection, and 4 for towards inevitable escapages, totaling to 740 TMC. Tribunal gave its report with the final decision on 5th February 2007. The report is in 6 volumes. As I have already said, all these reports are available on the websites of Central Water Commission and Ministry of Jal Shakti. Volume 6 is maps. These are some of the clauses of the final order and decision of the Cauvery Water Disputes Tribunal, which is in chapter 9, page 237 to 245 of volume 5. Clause 1 says, this order shall come into operation on the date of the publication of the decision of the tribunal in the official gazette under section 6 of the Interstate River Water Disputes Act 1956 as amended from time to time. Clause 2 says the agreements of 1892 and 1924 cannot be held to be invalid, especially after a lapse of about more than 110 and 80 years respectively. We'll see in the presentation that subsequently the Supreme Court gave a different decision about 1924 agreement. Various provisions of the agreements have been reviewed and re-examined on the principles of just and equitable apportionment. Clause 3 says present order supersedes the agreement of 1892 and 1924 so far as it is related to Cauvery River system. Tribunal award dated 5th February 2007, clause 4 says utilizable quantum of water of Cauvery at LC at 50% dependability is 740 TMC. 740 TMC was allocated to the states as Kerala 30 TMC, Karnataka 270, Tamil Nadu 419, Pondicherry 7, environmental and inevitable escapages 14. Someone I just saw a talk has asked how the tribunal has reached, has decided about 50% dependability. That we can just discuss at the end. Kerala's 30 TMC was distributed in the three sub-basins, Kabini and Bhavani Pambar at 21, 6 and 3. This is an important clause, clause 7. In a distress year, the allocated shares shall be proportionately reduced amongst the states. Clause 8 specifies the interstate contact points identified for monitoring water deliveries for Kerala, Karnataka, Tamil Nadu and Pondicherry. These are mentioned here. This is the monthly schedule of quantities which are to be delivered at Biligundu by Karnataka in a normal year, totaling to 192 TMC. From February to May, it is only environmental releases. Clause 9. The above monthly releases shall be broken in 10 daily intervals by the regulatory authority. The authority shall monitor the working of monthly schedule with the help of the concerned states and Central Water Commission for a period of 5 years and modify schedule if necessary. Annual allocation does not get changed. Utilizable waters include waters carried over from previous water year in all the reservoirs with effective capacity of 3 TMC and above. As on 1st June, the water year is from 1st June to 1st May. Clause 11 says upper states not to take any action so as to affect the scheduled deliveries of water to the lower riparian states. Clause 12, this is also important. Use of underground water by the states not to be reckoned as use of the water of the river Cauvery. About groundwater, we'll see that Supreme Court has given some verdict. Clause 13, whenever hydro projects, power projects in the common reach boundary are negotiated with National Hydropower Corporation and are constructed, the water stored and the pattern of downstream releases are to be consistent with the order. Clause 14 says use of waters to be measured by the depletion of the waters of the Cauvery, which include evaporation losses also. Consumptive uses for drinking water will be at 20% of the diversion and industrial uses at 2.5% of the diversion. Clause 15, state shall be at liberty to make use of water not utilized in a particular month in any other subsequent month during the same water year on approval by the authority. Clause 16 says inability to make use of some portion of water during any water year shall not constitute abandonment of share. Clause 17 says orders, directions, recommendations, suggestions in different chapters also hold good. Clause 18, nothing in the order shall impair the right or power of or authority of any state to regulate within its boundaries the use of water in a manner not inconsistent with the order. Clause 19 is about definitions. What is a normal year? What is irrigation season? What is TMC, etc.? Those are defined there. Clause 20, nothing in the order prevents alteration, amendment, or modification of any of the clauses by agreement between parties. Clause 21 is about the expenditure. This expenditure shall be shared in the ratio of 15 for Kerala, 40 for Karnataka, 40 for Tamil Nadu, and 5 for Puducherry. This is the ratio they have specified. Aggrieved by the final orders of the tribunal, Karnataka government approached the Supreme Court and filed a special leave petition against the final orders of the tribunal under Article 136 on 23rd April 2007. Kerala also filed SLP on 30th April and Tamil Nadu on 5th May 2007. They filed as special leave petitions under Article 136. Puducherry did not file any SLP under Article 36 before the Supreme Court. The SLPs of all the states came up before the Supreme Court on 7th May 2007. The Supreme Court admitted all the SLPs and referred the case to the larger bench, termed as Civil Appeal numbers 2453 of 2007, 2454 of 2007, and 2456 of 2007. Union of India was also pleaded as a party by the court order of August 2007. Civil appeals were in the Supreme Court list for February 2016. Under Section 5.3, references were also made before the tribunal by the party states. The Cauvery Water Disputes Tribunal met on 10th July 2007 and passed the following orders about Section 5.3 references. The petitions under Section 5.3 of the Interstate River Water Disputes Act 1956 have been filed on behalf of the states of Tamil Nadu, Karnataka, Kerala, the Union Territory of Pondicherry, and the central government against the final order of this tribunal dated 5th February 2007. It appears that the state of Karnataka, state of Tamil Nadu, and the state of Kerala filed special leave petitions against the aforesaid decision of this tribunal dated 5th February 2007 before the Supreme Court. The Supreme Court has granted special leave. The appeals are pending. According to us, in the background, these applications under Section 5.3 of the said Act should be listed for orders after disposal of the appeals by the Supreme Court. This was the decision. On 10th May 2013, the Honorable Supreme Court directed Government of India to constitute a supervisory committee for implementation of the final orders of the Cauvery Water Disputes Tribunal dated 5th February 2007. The Honorable Supreme Court in its order of 10th May 2013 indicated the formation of the committee as follows. Secretary MOWR as the chairman of the supervisory committee and the chief secretaries of the party states as members of the committee. Accordingly, by notification dated 22nd May 2013, the Government of India constituted the Cauvery Supervisory Committee, and afterwards, Cauvery Supervisory Committee started monitoring the order, and CRA and CMC, which we saw earlier, did not function. Civil appeal numbers 2453 of 2007 Karnataka, 2454 of 2007 Kerala, and 2456 of 2007 Tamil Nadu were taken up by the Supreme Court for final hearing commencing from 11th July 2017 and concluded on 20th September 2017. The states of Karnataka, Kerala, Tamil Nadu, and Union Territory of Pondicherry, as well as Government of India, have made their arguments and rejoined their arguments and have filed their submission notes before the Supreme Court. Union Territory of Pondicherry earlier did not file any SLP, but when they found that they said before the court that since they were thinking that these will be taken up by the tribunal, and now since the Supreme Court is hearing the complete matter, they requested for increasing their share from 7 TMC to 8 TMC. The Supreme Court on hearing of the civil appeals gave their final judgment on 16th February 2018. Important decisions in the Supreme Court order are: the court modified the allocations by allocating 14.75 TMC additionally to 270 TMC Karnataka, out of which 4.75 TMC is to meet the drinking and domestic needs. Accordingly, the quantity of water to be insured at Biligundlu in a normal year is reduced to 177.25 TMC from 192. The Supreme Court directed the central government for framing a scheme for implementation of the award. The order says, in the ultimate analysis, civil appeal number 2453 of 2007 filed by the state of Karnataka is partly allowed and all other appeals stand disposed of accordingly. There are some of other important decisions in the order. 1924 agreement expired after 50 years in the year 1974. The principle of equitable apportionment has been regarded to be the guideline for resolving disputes. Final determination of irrigated area arrived by the tribunal for Tamil Nadu cannot be declared incorrect. They concurred the assessment of the tribunal about this. Regarding Kerala allocation, tribunal's decision was conclusion was concurred by the Supreme Court. Supreme Court decided that allocation for Puducherry does not require any enhancement. 10 TMC of groundwater in Tamil Nadu be accounted for in the final determination of its share. This is very important. Tamil, this is actually the tribunal did not consider groundwater use. Supreme Court said 10 TMC of groundwater in Tamil Nadu be accounted for in the final determination of its share. Regarding water allocation for domestic and industrial purposes of the state of Karnataka, the order states that the tribunal had drastically reduced the share of Karnataka towards domestic and industrial purpose, for the reason being that only 1/3 of the city of Bangalore falls within the river basin, and also on the presumption that 50% of the drinking water requirements would be met from groundwater supply. The said view taken by the tribunal ignores the basic principle pertaining to drinking water and is thus unsustainable, keeping in mind the global status that the city has attained. An addition of 4.75 TMC is awarded to Karnataka. Revised water allocation among competing states. This is here it is mentioned in the Supreme Court order. With the evolution of the principle of equitable apportionment, which is really to ensure equal justice to the basin states, the concept of prescriptive right or right to the natural flow of any interstate river has ceased to exist. Having regard to the historical facts which demonstrate the constraints suffered by Karnataka, resulting in its limited access and use of surface water of Cauvery in spite of being the upper riparian state compared to Tamil Nadu, then Madras Presidency, as well as similarly conditions in its 28 districts or taluks, we are inclined to award an additional quantity of water to it in the measure of 14.75 TMC in all. That is 10 TMC on account of availability of groundwater in Tamil Nadu, plus 4.75 TMC for drinking and domestic purposes, including such need for the whole city of Bangalore. On these considerations, we consider Karnataka to be more deserving amongst the competing states to be entitled thereto. Out of this, 14.75 TMC would be deducted from the quantum allocated by the tribunal in favor of Tamil Nadu. So accordingly, the final allocations as per the Supreme Court order become Kerala 30 TMC as it is, Karnataka 270 plus 14.75, that is 284.75 TMC, Tamil Nadu 419 minus 14.75, that is 404.25 TMC, Pondicherry 7 TMC as it is, environmental releases 10 TMC as it is, 2.5 TMC per month, inevitable escapages to sea 4 TMC, totaling to 740 TMC. The state of Karnataka would be required to release 177.25 TMC of water at the interstate border with Tamil Nadu at Biligundu. About framing of a scheme, it is stated in the order that the framing of a scheme is exclusively meant for implementation of the award or as the same gets modified by this code, award of the tribunal. It is also stated that it is made clear that subject to the scheme to be formulated under Section 6A of the 1956 Interstate Water Disputes Act, in terms of the present adjudication, the recommendations or directives of the tribunal with regard to the monthly releases and not inconsistent with anything decided herein are hereby endorsed for the present for a period of 15 years hence, that is up to 2033. Civil appeal numbers 2453 of 2007 filed by the state of Karnataka is partly allowed and all other appeals stand disposed of accordingly. This is a table showing monthly releases at interstate border Biligundu to be followed after judgment of the Supreme Court dated 16 February 2018. Column 4 is as per the decision of the Cauvery Water Management Authority in its first meeting. CWMA in its first meeting felt that the environmental releases from February to May should remain as it is, 2.5 TMC, and the proportionate factor was applied from June to January for that is the irrigation season. So instead of 10 TMC as per CWDT order, it is 9.19 and so on. In accordance with the directions of the Honorable Supreme Court in the order dated 18th May 2018, the Government of India issued a Gazette notification of 1st June constituting the Cauvery Water Management Authority CWMA and Cauvery Water Regulation Committee CWRC. That notification, the authority shall consist of one chairman to be appointed by the central government, two whole-time members to be appointed by central government for a term of 3 years, extendable up to 5 years. Out of the two, one is one member water resources and engineering not below the rank of chief engineer from the central water engineering services cadre. One member agriculture, not below the rank of a commissioner in the Ministry of Agriculture and Farmers Welfare. Two part-time members, representative of the central government of the rank of joint secretary to be nominated by MOWR, RD and GR and Ministry of Agriculture and Farmers Welfare respectively. Four part-time members from party states who will be administrative secretaries in charge of water resources department of each state, government of Kerala, Karnataka, Tamil Nadu and duty of Puducherry, who shall be nominated by the state government and duty administration respectively. Secretary of the authority. The authority shall have a secretary who shall be an engineer to be appointed by the central government for a period of 3 years, extendable up to 5 years and not below the rank of chief engineer from the CWES cadre. And he shall not have any voting rights. All the members are having voting rights, but secretary is not having any voting right. He is not a member. Quorum and voting. 6 members shall form a quorum and the concurrence of the majority shall be necessary for transaction of the business of the authority except such business as the authority may from time to time prescribe as routine. The members shall have equal powers. During the third meeting of CWMA, it was decided that quorum of meeting will be considered as complete only if at least 3 members out of the 4 party states are present. The next meeting will be held within 3 days if the meeting is postponed for want of quorum, and for that meeting quorum will not be necessary. These are powers, functions, and duties of Cauvery Water Management Authority as mentioned in the Gazette notification. Storage, apportionment, regulation, and control of Cauvery water, supervision of operation of reservoirs, and with regulation of water releases therefrom, with the assistance of regulation committee, regulated releases by Karnataka at the interstate contact point presently identified as Biligundu Gauge and Discharge Station located on the common border of Karnataka and Tamil Nadu. As per 3.1 function, the authority at the beginning of the water year, that is 1st June each year, would determine the total residual storage in the specified reservoirs. As it is not possible to know the amount of season-wise river flows which will be available during a season, it will be assumed that the inflows will be according to 50% dependable year. The share of each state will be determined on the basis of the flows so assumed together with the available carryover storage in the reservoirs. The withdrawals will be allowed during the first time interval of 10 days of the season on the basis of the share worked out for each party state, limited to the water requirements during the same period indicated by each party state by placing an indent of water demand with CWRC. This is 3.2. I think the authority will take stock of the actual yield in the basin at the end of the previous time interval, as well as the utilization or releases and storage built up during the interval, and assess the trend of inflows and authorize withdrawals to the states for the subsequent time interval accordingly. For giving effect to the aforesaid provision, the authority may have to repeat this exercise for 2 or more time intervals. These are again a number of those functions are given in the Gazette notification. So I think I'll just skip these because these are all given in the Gazette notification. In case of deficiency in the water availability during any month, as reported by the regulation committee, the authority will consider reduction in the indent of the parties in proportion to the quantities allocated to each state by the tribunal as modified by the Honorable Supreme Court by the order dated 16 February 2018 for the designated crops. The regulation committee shall keep a watch on the actual performance of the monsoon during each 10 daily interval and report position to the authority indicating therein the extent of variation from the normal. The authority on receipt of such information will consider any change in the releases ordered by them earlier. Similar exercise will continue as the monsoon progresses during the succeeding months till the end of the water year, which is 31st May of every year. These are some of the other functions mentioned there. The authority or any member or any representative thereof shall have power to enter upon any land or property upon which any hydraulic, structural, or any work of gauging or measuring device has been or is being constructed, operated, or maintained by any agency in the Cauvery Basin. If the authority finds that any government of the party states, namely Tamil Nadu, Kerala, Karnataka, and Union Territory of Puducherry, do not cooperate in implementing the decision or direction of the tribunal, the authority can seek the help of the central government for implementation of the award of the tribunal as modified by the Honorable Supreme Court by the order of 16 February 2018. The Gazette notification By the Gazette notification, Cauvery Water Regulation Committee has also been constituted. The composition is full-time member water resources of the authority is its chairman, ex officio chairman, one representative of each state, 4 party states, not below the rank of chief engineer are members. One representative of India Meteorological Department of the rank of joint secretary is one of the member. One representative of Central Water Commission not below the rank of chief engineer dealing with the river gazing is member. One representative of Central Ministry of Agriculture not below the rank of commissioner is a member, and secretary to the authority is ex officio member secretary of CWRs. Functions of the committee are enumerated at para 18 of the scheme. Functions in brief are to collect daily water levels, inflows, and storage position at each of the 8 reservoirs denoted by the tribunal award as modified by the Honorable Supreme Court. To ensure 10 daily releases of water on monthly basis. To collect the data of water released from the 8 reservoirs. To collect daily water flows at Biligundu and keep the authority suitably informed. To compile and reconcile monthly water account for each reservoir. To collect and compile weekly hydrometeorological data, any other function referred by the authority. These are some of the financial provisions mentioned in the Gazette notification. The central government shall initially contribute a sum of 2 crore rupees for the functioning of the authority. All the capital and revenue expenditure required to be incurred by the authority shall be borne by the state governments of Kerala, Karnataka, Tamil Nadu, and Union Territory of Puducherry in the ratio of 15 for Karnataka, Kerala, 40 Karnataka, 40 Tamil Nadu, and 5 UT of Puducherry, respectively. Authority shall maintain detailed and accurate accounts of all receipts and disbursement. The authority shall maintain accounts which shall be audited by the Comptroller and Auditor General of India or his nominee. Now, I'll just take 2 minutes to inform about the achievements of Cauvery Water Management Authority and Regulation Committee in the last 2.5 years. Cauvery Water Management Authority 11 meetings have been conducted. Cauvery Water Regulation Committee 14 meetings have been conducted for effective monitoring of hydrometeorological situation in the Cauvery Basin. All the meetings, 11 meetings of Cauvery Water Management Authority and 40 meetings of CWRC have been held in a cordial atmosphere so far. Rules of business of CWMA and CWRC have been prepared and finalized. The monthly quantum of water to be ensured at the Biligundu site of CWC in a normal year in the light of the Honorable Supreme Court order dated 16 February was agreed by CWMA during its first meeting itself held on 2nd July, which we have seen that table. The annual and seasonal reports of water count for water years 2018-19 and 19-20 water years from 1st June to 31st May were prepared, finalized by CWRC and approved by CWMA. Further, arrangement regarding monthly apportionment of 7 TMC of water to be released to UT of Puducherry by Government of Tamil Nadu was agreed by the Cauvery Water Management Authority during its 5th meeting held on 25th February 2020. A proposal regarding first phase of the setting up of the communication network in Cauvery Basin as recommended by the CWRC was approved by CWMA. 8 designated reservoirs in Cauvery Basin, namely Harangi, Hemavati, Kabini, and Krishnaraj Sagar in Karnataka Mattur, Lower Bhavani and Amravati in Tamil Nadu, Banasur Sagar in Kerala, along with upstream, downstream and canal systems have been included in the proposal for online monitoring in first phase. Thank you.